Hello, everybody. My name's Robert King. We're here today for the webinar, The Thorough Investigation of a Workplace Incident. It's 1 o'clock. I know people are still joining, so we're still going to get started on time. I know a lot of you might be on your lunch hour or have other things to do. For those of you who don't know me, I'm a partner here at Bugbee Conkle. I've been with the firm since 1985. I've been a lawyer since 1983, and since 1987, I've done nothing but workers' compensation. So I've been doing this almost 30 years now. So I like to think of it as if any of you have seen those farmers insurance commercials, I know a little bit because I've seen a little bit. But every time I say I've seen it all, there's something new comes up. So those of you that do a lot of workers' compensation, you know what I'm talking about. Just every time you think you've seen it all, you see a claimant alleging a new kind of injury. But we'll go ahead and get started now. Investigating a workers' compensation accident is one of the most critical things you'll ever be doing. And the first question you have to answer is who should conduct the investigation? In my opinion, frontline supervisors are probably in the best position to do an investigation. The supervisors know the workers know the supervisors. Sometimes an injured worker is less likely to make things up or exaggerate if he's talking to a frontline supervisor because they know that they know what they're talking about. Frontline supervisors also are privy to information such as a worker's personal problems and rumors, things on the floor. They might know that Joe was hurt in a softball game or somebody did something. They have their ear to the floor and they know information a lot of people don't. Supervisors also know the job and the equipment. And that's critical because sometimes they'll know right off the bat, is it possible for someone to have been injured the way they say they've been injured? So knowing the job and the equipment can really help the investigation. Another option is professional accident investigators. Now that can be expensive, but if you get a claim that's has a high exposure, high visibility, and it may justify the cost of hiring private investigating accidents. They can recreate accidents, do accident investigations. That's another option available to you. Third option is private investigators. Private investigators can do background checks on employees involved in the accidents. They can do criminal background checks. They can get you a lot of information. You can also use them during the course of a claim also if you suspect someone is working somewhere outside their restrictions or working somewhere else when they say they can't work at all. Private investigators can really help. The next thing that's important in the accident investigation itself is the actual accident report. Dates and times are critical. I can't impress that information on you enough. When you're doing the accident report, make sure the things are as accurate and as complete as possible. You want to put down the exact location of the accident. That can be critical later on during the fighting of the claim itself. Put where the accident occurred, where they said it occurred, document everything. Find out exactly what happened or what the claimant alleged happened. Be very specific in this accident report. Take down exactly what the claimant's telling you, what the other people are telling you. You cannot get too much information and you can't be too specific. Some of this may sound like common sense, but I'm telling you, when you've been doing this for over 30 years, sometimes you see accident reports where the people filling them out didn't want to take the time to do it correctly. They're just doing the minimum they can. Impress upon your people that are doing these accident reports, they are very important and can make the difference between winning and losing a claim down the line. And emphasize to the person filling out the accident report, don't simply restate something as a fact simply because a claimant or another employee or somebody tells you. Use the word alleges. And that lets people know down the line, 3 months, 4 months, 6 months down the line, when they're reading this accident report in a vacuum, that it didn't necessarily happen the way the claimant or the witness said it did, but that's what they say happened. And we'll get to the difference in that. You'll see here in a little bit. But also get written statements from all people involved in the accident and all witnesses. Have them sign and date the statement. But having written statements ties people to their stories right away while the facts are still fresh in their heads. Many studies have been done. It's amazing how fast facts start leaving someone's memory. You got to do it the first day if possible, as quickly as possible. You want people to put down exactly what happened, what they saw, what people have said. If there's any inconsistencies in your investigation, don't hesitate to point them out. If somebody says something that can't be true, point it out in your investigation. That's going to be critical down the road. Don't be afraid to point out these inconsistencies. In fact, you should document them. Next, you have to interview all witnesses and supervisors. And sometimes I know this is hard to do, it's time consuming to do, but go out and actually talk to these people. Make sure the witnesses and the supervisors sign and date their statements. Now this may sound, again, like common sense, but I know a lot of employers now have electronic accident investigations, and the course of the software does not allow people to sign or date their statements. If this is the type of software or accident investigation program you have, I urge you, once the statement is complete, print it out, take it to the individual, have them sign and date it. That way they can't say later on down the road, that's not what I said, that's not accurate. But signing and dating the statements is very important. Have these people give you detailed descriptions of the incident. Find out what they say happened, how it happened, when it happened. As I said before, I know I sound like a broken record, but I've been doing this long enough to know a good accident investigation can win or lose a claim for you. So make sure you get the detailed description of the accident itself. The next thing I want to talk about is whether there is any signs or evidence of drug or alcohol at the time of the accident. Now, I know a lot of you have mandatory drug and alcohol tests after accidents that are done automatically, and that's a good thing. But the other thing you got to keep in mind that under Ohio's workers' compensation law, a mandatory drug test doesn't necessarily give you what's called the rebuttable presumption under the law that the accident was caused by the drugs or alcohol. What you've got to show is that there was a reasonable suspicion that drugs or alcohol were involved, and this suspicion must be documented. Well, how do you do that? You got a frontline supervisor who's been in an accident. Joe hurt himself. Supervisor's talking to Joe, interviewing Joe for the accident investigation, and Joe's eyes are bloodshot. You could smell the alcohol. Maybe you could smell the marijuana, whatever. You've got to have the supervisor or whoever's doing the investigation document that and use that as a basis saying, because of what I saw, because of what I smelled, because of what I perceived, the claimant was acting strange, he was slurring his speech. We felt he was under the influence of alcohol or drugs, and that's why we had the drug test done. So if you go to a hearing without a reasonable suspicion for having the drug test done, there will be no rebuttable presumption. However, if you do have the reasonable suspicion that drugs or alcohol was involved, and you document that, and it turns out that he does test positive for drugs or alcohol, then you can go to the hearing, and Ohio's law has what's called a rebuttable presumption that states that if you could show the person was under the influence of drugs or alcohol at the time of the accident, a rebuttable presumption then comes into place that it was the drugs or alcohol which caused the accident. That is critical. So I urge you, tell your supervisors, tell your accident investigators, if they see any evidence of drugs or alcohol, document it and put down in writing that that was the reason for the mandatory drug test. Now, even if you don't have a reasonable suspicion, mandatory drug tests can still be helpful. For example, you have the mandatory drug test after an accident, comes back positive. Joe tested positive for marijuana, cocaine, whatever. What I would do in that situation, depending upon the level of the drugs or alcohol in the system, get that to a doctor for either a file review or an IME and have the doctor say, in my opinion, that level of intoxication or that level of drugs was the proximate cause of the accident. So even though you don't have the rebuttable presumption, you can still use that positive drug or alcohol test to get medical evidence to say that level of marijuana in the system, that level of alcohol, in my medical opinion, that was the cause. So keep that in mind as you're doing this. So if you don't have enough to do a reasonable suspicion, use the mandatory drug test to your advantage by getting an IME done or a file review done. The next thing I want to talk about is medical releases. These are critical because you need to know, someone's going to file a claim, you've got to know their past medical history and their current medical history, and you can't do that unless you get medical releases. So get releases from the claimant for all his treating doctors, hospitals, medical providers, anyone who's treating him for this claim. It could be an MD, it could be a chiropractor, it could be the urgent care clinic, it could be the hospital, all the places. But make sure you get releases for everyone. Normally, I urge you to probably use the bureau release because that's the safest way to go, but be aware there are many medical facilities out there, many hospitals specifically, that need their own release. So getting medical records is a job in and of itself. For those of you that do it, you know what I'm talking about. I'd say most hospitals will not accept a bureau release. They want their own release. So you can build up your own little file. If you live in, say, Mount Vernon and people go to Knox Community Hospital, get the releases from Knox Community Hospital so you got them in your office, have the claimant sign them right then and there, and it makes things a lot easier. You need to determine the nature and extent of any pre-existing problems. Talk to the claimant. Go through the records. If you have someone who's alleging a back injury, you need to know, was he being treated by a chiropractor or a doctor up until the date of this injury for back problems? You don't know these types of things until you get the records. You need to determine how much treatment he's had. I've had a number of claims where claimants will deny ever having prior problems. You get the records, and they show they were treating up to within a day before this accident happened. I've even had claims where they were treating before they reported to their second or third shift job. So getting these records is going to be absolutely critical to determine the nature and extent of their prior treatment. Many times there can be a smoking gun in these records. So I can't impress upon you the importance. You know, you as an employer or have your third-party administrator, have your attorney, whoever is working with you in your workers' compensation program, get releases, get the records. You got it. To me, that's doing your due diligence before you even think about certifying or denying a claim. And I tell employers all the time, don't be afraid to put off certifying or rejecting a claim until you get the records. In fact, I would say when in doubt, reject a claim until you get all the medical records. You can always go back and certify a claim after the fact, but you only get one chance to deny it if you certify it up front thinking, oh, it's just a simple back strain, no problem. Once you certify it, you're pretty much done. So do your due diligence, get the releases, get the records first. And again, also look to get the records after the injury. Now, this may not be important for whether or not an accident occurred at work, but I've had situations where the day after an injury, someone's in a car accident. So the reason they haven't come back to work is not because of the accident at work, it's because of the car accident or a slip and fall on ice. So just don't limit your records to the date of injury and before. Get the records after the injury, especially if you got a situation where the claimant doesn't file a claim for a year or more. They have 2 years to file a claim. So a lot can happen in that interim period. So make sure you also look at the records after the accident. Next thing I tell you to do is take photographs, videos of the incident site, all the involved equipment. They always say a picture speaks 1,000 words, and that's true, especially if you're in a hearing 6 months or a year after the fact. if you're sitting there trying to explain to a hearing officer what happened or what something was or what a process was, it's much easier to show a photograph or a video. This is especially true if you have someone who is on a job alleging a wear and tear injury. I always tell the employer, make a video of the job. We can show that video to the IME doctor, and then the doctor has an absolute understanding of that job. In fact, I just had a hearing this past week with one of the people who's on the listen to this seminar, and she knows who she is. But we had a video of the job. We sent it to the claimant, his attorney, a month before the hearing. At the DHO hearing, everybody talked about it. They had a new attorney at the next hearing saying, "Well, I've never seen the video." The claimant says, "I've never seen the video." We could prove. We sent it to him. It was filed on ICON. Hearing officer thought that was important. So videotape accidents, videotape jobs. To give you a little example of how important this can be, I actually had a jury trial years ago where the claimant alleged he was pushing a cart. The wheel in the cart hit a bolt in a crack in the floor. Cart came to a jarring stop. He injured his low back. That claim actually ended up in court. Luckily, the employer, workers' comp rep in the plant, went out to the exact area where the claimant said he was hurt, pinpointed the exact spot, and there was no crack in the floor. There was no way there was a way for the bolt to get stuck in a crack. They actually appealed that into court. It's the one and only court case I've ever done in my life where I did not have a doctor as an expert witness. We relied totally on the fact that we pinned down through investigation exactly where this claimant said the accident was. We went out, took videos and photographs of the exact location. There was no crack in the floor, therefore there was no bolt to get stuck in a crack. So it all boiled down to the claimant's credibility, and I'm happy to say truth, justice, and the American way prevailed, and the jury came back 8-0 in favor of the employer and disallowed the claim. So investigating, videotaping, all very critical. Document the scene of the accident. Take measurements. Document the scene as much detail as possible. You might not know during the initial stages of the investigation what's important. It might turn out later that it's critical that the table the part was on was 36.5 inches off the floor. So do all these type of detailed measurements. Like I said, you might not think it's important now. 6 months from now, it might be the evidence that wins you the claim. So do measurements, document everything. Keep in mind, the whole point of this is claims are expensive. Claims cost a lot of money. For 2016, temporary total compensation, the maximum rate is $885 a week. That's over $46,000 a year in tax-free money. That's right. Workers' compensation is tax-free. S&A benefits are not tax-free. They're taxable. So claimants, especially savvy claimants, they know what they're doing. If you have a chance to make $46,000 tax-free sitting home doing nothing, a lot of people are going to jump all over that. So money is the reason these things are driven. Throw on top of that payment of medical bills, permanent partial disability awards, wage loss compensation. You can see the costs just keep adding up. These claims can get very expensive. It's not unusual for a herniated disc surgery costs well over $20,000. So if someone has a back surgery, is off work 3-4 months, you've got a $50,000 claim in the blink of an eye, and you're going to have to reserve that up front. That's money the company has spent. So claims can be very expensive. This is why it's important to put a little money into your accident investigation now. Things to consider during the investigation itself. Claimant's age. Why is that? Well, if you get a claimant, I had a claimant this morning, back injury, 72 years old. What's the first thing that pops into my mind when you have a 72-year-old claimant? Degenerative disc disease. I guarantee you there's not a person walking around out there in their 70s that doesn't have some type of degenerative problems in their back. Arthritis, disc disease, whatever. So these are the type of things you got to consider early on. Likewise, if you get a 20-year-old claimant with a blown out disc, That's pretty rare that you would have a young person. So something might have happened. So just consider the claimant's age. The nature of the alleged medical conditions. Now, are we dealing with a simple lumbar strain? Are we dealing with aggravation of pre-existing degenerative disc disease? Are we dealing with spondylolisthesis, a rotator cuff injury? These are the type of things you got to look at during your investigation. Is it possible for this job process, for this type of injury, to have caused the medical condition at issue? For example, you deal with something like an impingement syndrome or rotator cuff injury. Normally, for an impingement syndrome, your job is going to have to be over-the-shoulder work. Well, you have a claimant whose job is performed at waist level or below, and he very rarely, if ever, goes above shoulder level. Those are the types of things you have to document during your investigation because it's going to be critical down the road. Is the claimant a good employee or not? And why do you ask that? If you get a bad employee, they're much more likely to try to scam the system. If you got a good employee, maybe you're willing to give them the benefit of the doubt. But these are the types of things you have to look at early on. Do they have other workers' compensation claims? If they do, they know the system, they know what they're doing. If they've already had a couple of claims, they've got an attorney, they've got a treating doctor or chiropractor that knows the system, those are all red flags. What's your role in the process? You gather all of the alleged facts from all the information on the incident. Never assume anything, always do the investigation. Don't go into any claim assuming someone's telling you the truth or someone's being accurate. I mean, I could tell you stories forever about how people I see where workers' compensation reps got into trouble because they believed the claimant's story, didn't do the investigation, they certified the claim, and it turned into a much bigger deal. As if they'd have done a simple investigation at the start of that claim, the claim never would have been certified. Good example, how not to report these facts. You read accident reports where someone says the employee was injured when he stepped on a ladder and felt pain in his low back. Well, that's what the claimant told the person doing the accident investigation. You put that on a form, fast forward 6 months where I'm at a hearing, claimant's attorney lays this down and says, look, your own supervisor said he was injured when he stepped on a ladder. Now I'm fighting that, no, that's not what my supervisor meant to say. He's just quoting from the claimant. Don't put yourself in that situation. What should you do? You put the employee said he was injured. It's as simple as that. Just put in the said part. Put in alleges. You just want to put on the accident form, this is not your supervisor's opinion. This is not your supervisor talking. I'm just documenting what the claimant told me. So just remember that and you have to educate your frontline supervisors or the people filling out the accident reports. How is this report going to look 6 months down the road to someone who wasn't involved? Make it clear that this is an allegation or this is what somebody is telling you. Just don't put down exactly what they say so that it looks like that's what you're supporting. Let me give you a quick case study and show you how important these types of investigations can be. I had a claim a number of years ago. It was at a tank farm. When I first heard that, I'm thinking, I didn't know they had farms where they raise tanks. But of course, that's not true. It was tanks of oil. And the employee was walking the perimeter of the farm and he claims that a branch fell, hit him in the head. Now, he doesn't remember this because he's got a concussion and total memory loss. But the individual walking the perimeter with him, this is what he says happened. He says the coworker claimed that he was walking the perimeter, branch overhead broke, fell, hit the claimant in the head, knocking him unconscious. This was a huge injury, skull fractures, eye fracture. I mean, massive exposure in this claim. So we started doing an investigation, and this picture shows, you can tell at the bottom of the picture where all the trees are, there's a fence running along there and a road. Well, they were walking that fence on the outside of the property. There is the branch that they say fell and hit this guy. I actually went out with the company's investigator to look at this, and we took these photos. We went up there and looked, well, this doesn't look like a branch. And you look at it, it's a log. It's a log that had moss on it. This thing had been laying there for years. In fact, We start talking to different people and found out all sorts of information. Then we start gathering the information. And this was the one and only one of their few screw ups in this was that when Life Flight came to get this guy, his coworker told him they were cutting trees in the woods and the branch struck him. That's the only reference to that. But once we got the records, because we went out and got the releases, did everything we were supposed to, we figured something's up. Their stories have changed. We talked to the guy that normally mows the grass. He said, well, yeah, that log had been there forever. In fact, I had to mow around it. It was sort of a pain in the butt. The guy's stories became too perfect after that initial flight log. I mean, the red flags are going off all over the place. So we started doing an investigation. And to make a long story short, it turns out this woods had trees of black walnut. And from what I was told during this investigation, black walnut's worth its weight in gold. They use it. It's a very expensive wood. They use it for fine furniture, things like that. These guys were on company time cutting down black walnut from adjacent property owned by someone else. And the tree fell on him. That's how he got hurt. Like I said, the company investigator came in from Chicago. We went out there. We looked at all this. Once we had enough facts to prove the claimant's coworker was not telling the truth, keep in mind the claimant himself was alleging total amnesia. They ultimately say, well, I'm changing my story now, and we were mushroom hunting when the branch fell. Well, interestingly enough, even if you're mushroom hunting, that's a deviation of employment, and so it wouldn't be a compensable claim. But I still didn't believe him. Eventually, the coworker cracked. He was afraid of losing his job. He told the truth. That's when all this came out. But it never would have got to that point had a thorough investigation not been done. We went out and investigated immediately. We took photographs, measurements. We got medical releases. We got the initial records. And trust me, a lot of people might not even have gotten the Life Flight records. They would have just started at the hospital. But that Life Flight record was what sent up the first red flag to make us know something was going on here. And as you can see, that claim probably easily saved this employer $500,000 because this claimant was off work all over a year, skull fractures, cheek fractures, amnesia. I mean, the list goes on. The medical bills were out of the woods. So I can't impress upon you enough how much money you as an employer can save by doing a proper investigation. I hope you've all enjoyed this webinar today. I hope you picked up something that can help you in your job, make you a better accident investigator. Thank you all for coming today. Enjoy yourself and have a good day.